Sir, good morning, sir. Patnaik sir, our President, Sri Madhusudan, our Vice President 1, MEAI, Sri Narsai sir, Secretary General, MEAI, and all senior members of Bangalore chapter and all other members joined from different parts of the country. Special Mr. Muralidhar Bidri is the Director of Mine Safety, Bangalore region. Sri Venugopal Swami, Deputy Director, Bangalore region. Mr. Vijay Singh, Vidyarthi Saab, Dr. Venugopal, Krishnamurthy, all my senior colleagues in Bangalore chapter. So good morning to all of you. Today we are here for a webinar, national webinar on decoding the occupational safety, health and working conditions code 2020. So government of India has passed this bill in parliament, and they have come up with a notification also. Now this will, I think this will be applicable to the industry from 1st April 2021. So keeping this in mind, this is the right time to enlighten and to educate the mining community about the new bill, since this is a very long due. All these years we are operating with the Mines Act 1952, so and other acts. Now this code has come with a different mandate, and including so many other laws into it. So with that, I think this is the right time. So that's why Bangalore chapter has taken initiative to start this webinar on this subject. So today we our Sanjay Kumar Patnaik sir is the President MEAI, because in spite of his busy schedule, he has accepted an invitation and to be with us as the chief guest. So I welcome you, sir. And Sri Madhusudan, our Vice President 1, MEAI, and so he has also accepted an invitation, and he is always supportive to all the chapters, especially Southern region. So I welcome you, sir. I welcome Sri Narsai sir, our Secretary General. So he also accepted our invitation and he is with us. And I welcome Sri Muralidhar Bidri, Director of Mine Safety, Bangalore region. So he, in spite of his busy schedule, so he accepted our invitation, and he is very readily accepted to deliver his speech on this subject. So along with Deputy Director Sri Venugopal Swami. So I welcome you, sir. So I welcome Sri Vijay Singh. He is a well-known person in MEAI and almost in the mining industry. I welcome you, and I welcome all the senior members and my colleagues in the Bangalore chapter, all the office bearers, our Secretary Mr. Rajendran, Mr. Dr. H.S. Venkatesh, and all other senior members. So I think with this now we'll go ahead with our program. Now I request our Secretary General Sri Narsai sir to say a few words about the theme of this webinar, because he is well versed with Mines Act 1952, and I think he is also know what is coming, the code. So I think he is the right person to start this webinar. I request Sri Narsai sir to speak about this code, sir.
Sanjay Kumar Patnaik, President MEAI, Sri Madhusudan Garu, Vice President 1, MEAI, Sri Muralidhar Bidri Garu, Director of Mine Safety, Bangalore region, and Sri Venugopal Swami, Deputy Director of Mine Safety, Bangalore region, Sri Dhananjay Reddy Garu, Chairman, Bangalore chapter, Sri H.S. Venkatesh, Vice Chairman, Bangalore chapter, Sri Rajendran Garu, Sri Vijay Singh Garu, and other Deepak Vidyarthi Garu, all who are very learned persons and about to learning. Good morning to all, everybody. First of all, I thank Dhananjay Reddy Garu for giving me an opportunity to speak about decoding of occupational safety, health and working conditions code 2020, organized by Bangalore chapter. So first of all, I congratulate Dhananjay Reddy Garu for organizing this webinar. Bangalore has been always in forefront for conducting such webinars on the current topics. My congratulations to Dhananjay Reddy and his team. As most of you know that the Occupational Safety and Health Working Conditions was passed in both the House of Parliament in September 2020 and by Ministry of Labour, Government of India, and undertaking job of modifying the 29 acts which are very old, redundant, not fitting to the changed conditions of the industry. Thus, all the 29 acts were subsumed and made into 4 codes, which are: one is Wage Code, 2 is Social Security Code, 3rd is Industrial Relations Code, 4th is Occupational Safety, Health and Working Conditions Code. Of the above, today we are holding webinar on this OSH code. This Occupational Safety, Health and Working Code was formed combining 13 acts. One is Factories Act, Plantation Act, Mines Act, Working Journalist Newspapers Employment Act, Working Journalist Fixation of Wages Act, the Motor Transport Workers Act, the BD and Cigar Workers Act, the Contract Labour Act, the Sales Promotion Employees Act, the Interstate Migrant Workers Act, the Cine Workers Act, the Dock Workers Act, the Building and Construction Workers Act. All these 13 acts were having about 633 sections, which were very elaborate and redundant. Some of the sections, and they were made into one code with 143 sections. These the proposed code simplifies, amalgamates, and rationalizes the provisions of the aforesaid 13 acts. The important changes are in this act are: the provision is to impart flexibility in adapting technological changes and dynamic factors in the matters relating to health, safety, welfare and working conditions of the workforce. Second is to apply provisions proposed for all establishments which have 10 or more work persons. Third is to provide registration for all establishments. Fourth is to include journalists working in electronic media also, and to provide issuing appointment letters to the contractor workers, which was not there earlier. It is to provide for cost of health checkup annually by the owners, which is mandatory for after this code, health checkup. Then it is also made provision for interstate migrant workers to provide interstate migrant workers with portability for availing the benefits of the government sanctioned. And it is also provide to constitute a national occupational safety and health advisory, which prescribes what are the conditions followed national safety health worker code. And it also provides provision for constituting state occupational safety and health advisory board. This board was essential because as per our experience earlier, lot of these silicosis cases were there, which were referred to even Supreme Court. Supreme Court constituted a committee for following up these cases. So when these cases were being followed, the state government activity was very less. So it was felt that the state also should take an important role for controlling or taking part in controlling these occupational health and diseases. So that's why a provision has been made for constituting a state occupational safety and health advisory board. It also makes a provisions for consideration of the safety committees in certain class of establishment where employment is more, which was there only in the mines. It also provides an employment of in all establishments and in all types of markets, and also in the night shift, which was not there earlier in the mines after 6 p.m. and up to 7 a.m. It also makes provisions for common license for all establishments, and a new provision is made for the courts to provide 50% of the penalty amount to the victim or dependents of the victim in case of the death. It also provides the powers of the central government for regulating general safety, health of the persons in the event of the epidemic and disaster. So, it also makes the provision for social security fund and also to make provisions for adjusting penalties imposed under this code. The Occupational Health Safety Code, in nutshell, has provided more benefits to the unorganized sector, which they are about 90%. In organized sector, only 10% work persons are there. Keeping this in view about the health, safety, welfare of the unorganized work persons, this Occupational Safety Health Code has been made, and with the provisions made, this Occupational Health Safety Code has 14 chapters. Out of 14 chapters, it has 143 sections. So, as far as mines are concerned, whatever the mine sections are there, most of them have been remained intact except minor changes. But however, there has been a good provision has been made regarding the contract work persons. Their protection has been ensured through these laws. It is a very welcome decision, and it will definitely help to the work, especially contract work persons engaged in mines as well as unorganized sector. So, with this, this webinar will go and in a long way in explain to the most of the participants about the code and benefits with the other speakers, Mr. Muralidhar Bidari and Venugopal. They will speak clearly about the sections. So, thank you very much once again to Dhananjay Garu for giving me this opportunity. Thank you one and all. Thank you.
Sir, thank you very much, sir, for your brief about this mining code. So, thank you very much, sir. Now, I request your Vice President Mansuzan Garu to say a few words about today's webinar. I request you to speak few words, sir. Mr. Mansuzan Garu.
Good morning, sir. President, sir. Narasaya, sir, Secretary General, Chairman of Bangalore chapter, and DMS Murali, sir, other DMS officials, Vidyarthi ji, and speakers, Jay Singh, sir. It is a privilege to present and address this important webinar, Decoding the Occupational Safety, Health and Working Conditions Code 2020, organizing by MEAI Bangalore chapter. This is a Bangalore chapter is a vibrant chapter. Always they are conducting continuous webinars. Every 2 months once they are conducting a webinars. Resource wise, number of seniors are available in this chapter. And even topic wise, if you see different people are available at this chapter, we should utilize, and we are utilizing this opportunity. When Dhananjay Reddy team is utilizing this opportunity, I will congratulate MEAI Bangalore chapter for conducting of these continuous webinars, and also let us congratulate Bangalore chapter members for acquiring of a new office building recently at a prime location. It is a great achievement by the Bangalore chapter. We appreciate from the MEAI, and it is also giving an immense pleasure to acknowledge the efforts of various MEAI chapters all over India. They are also conducting a lot of webinars which are giving a lot of knowledge to the people and interaction within the mining fraternity. during these difficult pandemic situations. And regarding eminent speakers, Bangalore chapter has invited Sri Muralidhar Bidari sir and Venugopal sir and Mr. Vijay Singh. They will give a full knowledge about decoding of this OSH code 2020. As you know very well, this code has been notified by the central government, and it gives lot of more focus on workplace safety and health conditions at workplace. It is a fact that employees have a right to expect good, safe and health working condition at their working place, even though it may seem workplace and health and safety is an obligation to the businessman, but it is an advantage towards productivity and the loyalty of the employee towards business. So, business owners must understand that the safe workplace is a key component to developing a positive corporate culture. As per my view and feeling, workplace is an important location for successful strategies. Any strategy if you want to implement, if you are implementing at a workplace with the employees, so that is going to be a major role that gives results. And nowadays, in the world, all companies they are seeing work-life balance. This is also a very important point for the employees as well as businessmen. Now, present code is also dealing with more on this work-life balance. They are taking care of safety, taking care of health, taking care of employee work location, environment. It is giving a more press on these three things. More focus on occupational safety and health is in three different objectives. One is promotion of workers and safety at workplace. Improvement of working environment is also one of the more conducive to safety and health. Development of organization and working culture towards employees, safety and health, all these things. Culture also has to be improved. If you focus on these lines, then automatically business will flourish and employees also will be very happy and you will get a good productivity as well as profitability. With these few words, I'll conclude my speech, and I'll always happy that Bangalore chapter is doing a very well job. I am very thankful to the organizers for calling me for this webinar as a guest of honor. Thank you once again. Thank you all.
Thank you, sir. Thank you, Masoon Garu, for your wonderful insight into the features of this code, and thank you very much for your well thought words about Bangalore chapter. I thank you very much. So now I request our President Sri Sanjay Kumar Patnaik sir to deliver his chief guest address on this occasion. So over to Patnaik sir.
Good morning. Thank you, Mr. Dhananjay Gurua Reddy, for first of all inviting me for this very important webinar. And as my colleagues in the MEAI Council, National Council have already mentioned, you know, Bangalore chapter has been one of the foremost chapters in MEAI, which has been driving the promotion of the MEAI activities in that region, and they have been conducting excellent webinars, a wide range of topics covering the entire gamut of operations in the mining sector, including the workers' welfare and digital mining and so on and so forth. So once again, I want to compliment you as the chairman and your team for organizing this webinar on a very new topic. So, ladies and gentlemen, I have the privilege of welcoming and welcoming Mr. Madhusudanan, our Senior Vice President, and who has just given his thoughts. We have Mr. Narseya, the Secretary General of MEAI, the key person who is driving all the initiatives at MEAI headquarters. And on my personal behalf and on behalf of MEAI, it's my privilege to welcome our speakers. Very distinguished, I see Mr. Murlidhar Bidari, the DMS Bangalore region. Thank you for coming and accepting our invitation, sir. On behalf of MEAI, I welcome you. Mr. Venugopal Swami, the DDMS Bangalore region, is also another speaker, and I find our very energetic MEAI member in the National Council for several years, Vijay Singh, who has always been, let me tell you, very active in promoting new topics and speaking his mind out and analyzing it in a very critical manner. Some of his presentations, people who have attended would find it very, very interesting and all that, because he goes deep into the subject. So thank you, Vijay, for also speaking on this subject. You would be speaking on this subject, and of course, Dhananjay, Mr. Venkatesh, Mr. Rajendran, and all my other colleagues. I also see Mr. Deepak Vidyarthi, Mr. Venugopal, very senior people. We are proud to have them as active MEAI members in our National Council. The topic that has been chosen, as Madhu has already shared, Mr. Narseya has already said, topic has been chosen, is really an interesting topic because it talks about the workers' welfare. As we, as a country, as we graduate from developing economy to a developed economy, it is important to meet the aspirations of our people, and we have a very young demographic. And it is also important as for looking after the safety, health, working conditions and welfare of our workmen, because that is where the company becomes more profitable. That is where the company really has gets the long-term dividends and all. So I would say that this code which has come out is a very forward-looking and futuristic code, and it has sort of replaced many of the archaic rules, cumbersome rules, and made it more simpler, which promotes the ease of doing business. So it is already, as my previous colleagues have already told, that it has already got the presidential accent, and it's going to be notified soon. Some of the highlights, some of the points which I was going through, some of the points which really attracted me and which are, I would say, are quite futuristic and in the interest of both the employees as well as the employers, is this provides a single registration. This replaces some 13, as Narseya said, some 13 old acts and all that, and this has a single registration instead of multiple registrations, and there is provision for a centralized database which would help the ease of doing business. Appointment letters have been made statutory in this. Working hours for women, which I think very important. Any country which develops has to take care of its women workforce. So therefore, as per the new provision, female workers or women can work during night shift with their consent. So that's a forward-looking step. The rights and duties of employees and employers have been well defined. The rights are laid down in the code. Employees also have a responsibility. Employees are also responsible for their own health, for their own safety, and they are supposed to report the unsafe practices, unsafe working conditions and practices in the area where they are working and all that. So they also, employees do have a responsibility. It's not only all the time the employer. The code also covers the audio-visual production, which includes feature films, non-feature films, television, web-based serials, reality shows, and the new definition of audiovisual workers, singers, news readers, and technical artists, all are covered and all that. So this is also a very welcome step. The definition of contract labor has been modified and includes interstate migrant worker. All of us would recall the horrifying pictures that we saw on the television after the lockdown. People walking hundreds of kilometers to their villages, which was really heart-rending. And as a nation, I think it didn't give us a good feeling and all that. So therefore, I think when these contract workers, which includes the state migrant workers and regularly employed and mutually accepted standards and conditions of employment for them. So these are also good social security benefits for them. It also talks about the sales promotion employees, which has been revised, including persons in supervisory capacity, administrative capacity, getting a salary of 18,000. And the definition of worker has also been revised, which includes persons in supervisory capacity, working generally, sales promotion, and so on and so forth. So therefore, some of these points, actually, if you look at it, has given a sense of security to our workmen. As Narsan said, that most of the unorganized sector will stand benefit from this code and all that, and which all of us should support and look forward to successful implementation of this code. Government seems to have made very conscious efforts towards balancing the rights of the employees as well as the employers. So it is not only that the employees as well as the employers, both, as the government has made. And certain new and interesting concepts have also been introduced, including the provisions in relation to fixed term employees, worker reskilling fund. This is very interesting. Worker reskilling fund, social security for gig workers and platform workers, definition of core activity for engaging contract workers, contract labor, recognition of trade union, notice period for strikes, compounding of certain offences, etc. So it has a very holistic approach, and the practical functionality and implementation of this successfully, if it is done in a very pragmatic manner, then I think it will reap benefits for the country as a whole, for our society, for our people, and for the industry, overall for the industry. Efforts have been made to simplify things by the government, simplify the regulation. Efforts have also been to improve the welfare measures, but it is now up to the industry, up to the trade unions, up to the employees themselves to see that this is successfully implemented, and all of us reap the benefit. These are some of my observations on this futuristic code, and once again we would look forward to hearing from the experts, the three speakers who will, I'm sure, deal with it in detail. And once again I thank Dhananjay and for organizing this, and I must also take this opportunity to congratulate Dhananjay and his for having this new office building. We go and see how the office is looking. Thank you for giving me this opportunity. Thanks a lot.
Sir, thank you very much, sir, for taking time and spending time with us today, and you are delivering your chief guest address and highlighting the important aspects of the new code. So I thank very much on behalf of Bangalore chapter for taking time, sir. Thank you very much, sir. I think with this now we'll go to the actual technical presentation area. Now with us is Mr. Muralidhar Bidri, the Director of My Safety Bangalore region. I think he does not need any introduction, but as a customer, it is my duty to just introduce him. Sri Muralidhar Bidri is passed out from National Institute of Technology, Surat, in the 1994. And he is a first-class mine manager, certificate holder in coal as well as metal. And he joined underground mines and has a good experience in underground mine. Then he joined DGMS as the Deputy Director of Mine Safety. And more important is he is the person who was completely involved in making up this code. Since he was in DGMS headquarters at Bangalore, so he knows complete nitty-gritties of this code, and he is completely involved in this. And fortunately, today he is at Bangalore and in Bangalore region. So we are fortunate enough that he knows everything about the code. And with this, I think we'll start our technical presentation. I request Sri Muralidhar Bidri sir to go ahead with his presentation. Over to Mr. Bidri sir. Sir, just on intervention. Bidri sir, just on intervention. Yeah. So I think one more thing I forgot to mention. So today's webinar was sponsored by our Vedanta Limited and DRM Group. So they have sponsored this program. I thank management of Vedanta Limited and our DRM Group for sponsoring this today's webinar. I think now we'll go ahead with Mr. Bidri sir.
Good morning to everybody. Respected Patnaik ji, President MEAI, respected Madhusan ji, VP MEAI, respected Narsaya Saab, Secretary General, Dhananjay ji, and my friends. Today we have scheduled the webinar on OSH code, which has been passed by the Parliament, which we have discussion. I expect participants to discuss after the presentation what are the views, opinions they have. And the rules under this code also has been already published, and this is in the public domain. And details to all this effect will be covered in the presentation. Without taking much time, I request Venugopal sir to go ahead with the presentation, and so that we can discuss effectively. Venugopal sir, please. Thank you. Good morning to everybody. Respected Patnaik ji, President MEAI, respected Madhusan ji, VP MEAI, respected Narsaya Saab, Secretary General, Dhananjay ji, and my friends. Today we have scheduled the webinar on OSH code, which has been passed by the Parliament, which we have discussion. I expect participants to discuss after the presentation. What are the views, opinions they have? And the rules under this code also has been already published, and this is in the public domain. And details to all this effect will be covered in the presentation. Without taking much time, I request Venugopal sir to go ahead with the presentation, and so that we can discuss effectively. Venugopal sir, please. Thank you.
Good morning, everybody. First of all, I wish to thank MEAI Bangalore chapter for inviting us to this program and giving us an opportunity to present, to decode the OSH code. I thank whole team, Sri Dhananjay Reddy garu, Sri Sanjay Kumar Patnaik Saab and Vijay Singh Saab and rest of the MEAI members, a very good morning. Without wasting much time, I am going to the presentation. Kindly so welcome to the webinar on the Occupational Safety, Health and Working Condition Code 2020. Organized on 18/12/2020 by MEAI, presented by Sri M. Bidri, Director of Mine Safety, and accompanied by me, K. Venugopal Swami, Deputy Director of Mine Safety. So, before going into the code, let us have a look why OSH code has formulated or come into force. It is that the Constitution of India provides detailed provisions for the rights of the citizen and also lays down the directive principles of state policy which set an aim to which the activities of the state are to be guided. On the basis of these directive principles as well as international instruments, government is committed to regulate all economic activities for management of safety and health risk at workplaces and to provide measures so as to ensure safe and healthy working conditions for every working man and woman in the nation. Government recognizes the safety and health of workers has a positive impact on productivity and economic and social development. Prevention is an integral part of economic activities as high safety and high health standards at working is as important as good business performance for new as well as existing industries. Let us have a look at national policy on safety, health and environment at workplace of Ministry of Labour and Employment, Government of India. Okay. You see, this is the Government of India, Ministry of Labour and Employment. National Policy of Safety and Health Environment at Workplace.
It's coming,
see,
sir.
The National Safety Policy. National Policy of Safety, Health and Environment at Workplace aims at continuous reduction in incidences of work-related injuries, fatalities, diseases, disasters, and loss of national assets. It also aims to improved coverage of work-related injuries, fatalities, and diseases, and provide for a more comprehensive database for facilitating better performance and monitoring. Continuous enhancement of community awareness regarding safety, health and environment at workplace related areas. Continually increasing community expectation of workplace health and safety standards improving safety, health and environment at workplace by creation of green jobs, contributing to sustainable enterprises development. By means of, this can be achieved by means of developing appropriate standards, codes of practices and manuals of safety, health and environment for uniformity at the national level in all economic activities consistent with international standards and implementation by stakeholders in true spirit. Ensuring stakeholders awareness of and accessibility to applicable policy, documents, codes, regulations and standards. Action program has how this can be achieved. There is an action program. The action program includes enforcement, national standards, establishment of national standards, compliance of that standards, awareness about the codes are formulated among the stakeholders, continuous research and development, occupational safety, health, skill development, data collection and management, an approach to e-governance, continual review and development. State has committed to review the national policy on safety, health and environment at work and legislation through tripartite consultation, improve enforcement, compilation analysis of statistics, develop specific program for hazardous operation and other focus sectors, set up training mechanism, create nationwide awareness, arrange for the mobilization of available resources and expertise. So, let us go to OSH code working condition. This is the background OSH code from which it has been formulated. You see, main highlights of this OSH code. It has merged 29 labor laws merged into 4 labor codes, out of which 13 acts subsumed into OSH code. Most of the acts were enforced over 50 years. By reducing 622 sections into 143 clauses or sections, this code is applicable to all the establishments with 10 or more workers, except in cases of mines where it is applicable even if one worker is employed. Code is not applicable to the offices of state and central government. Why code is required? Labor is concurrent subject under the Constitution of India, means center as well as state have power to regulate it. The large number of laws are enacted catering to different aspects of laws. Different aspects of labor. There exist more than 100 state laws and more than 40 central laws across industries, occupation and region. Large number laws overlapping with each other, having tedious compliance. India is booming its economy. Labor laws need to be reformed or restructured. How this code was formulated? After a gap of almost 72 years, Second National Labour Commission has been constituted under the chairmanship of former Union Minister, Labour Minister, Dr. Ravindra Verma, was set up on October 15, 1999. On June 29, 2002, he presented the report and suggested the need for bringing the existing laws in tune with the future labour market needs and demands. The Commission also recommended to subsume the existing laws into 3 to 4 labour codes that can address whole spectrum of labour laws. On being tabulated, the draft bill was referred to the Parliament Committee, which suggested 100 changes, out of which 74 are accepted and incorporated. Bill passed in the Parliament on 23rd September 2020. And this is the background of formulation of the Occupational Safety Health Code work condition health code. You see, the 4 codes, mainly the Wages Code, IR Code, Industrial Relation Code, Occupational Safety and Working Conditions Code, and Social Security Code, All these made a drastic reforms, we may say, already significant changes for welfare and benefit of the labor employed in the fields. Now, what are these 13 acts that are repealed? You all might be knowing, but once again I revise them. The 13 acts repealed and subsumed into OSH Code 2020. They are the Factories Acts 1948, the Plantation Labor Act 1951, the Mines Acts 1952, the Working Journalist and Other Newspaper Employees Act 1955, and so on. Like that, there are 13 acts which are subsumed and made into one single Occupational Health Working Conditions Code. You see, there is a small gist of major difference between the Mines Act of 1952 and OSH Code Working Condition Code 2020. The Mines Act was enacted from and extended to all of India, and on date it still prevails as the law of the land. OSH Working Code has been passed by the Parliament but not yet been enacted, will come into force on the date as may be modified by the central government. Thereafter, the Mines Act will be repealed and subsumed by that date. Earlier in Mines Act, the Chief Inspector means the Chief Inspector of Mines appointed under the Act. Now, here it is called Chief Inspector cum Facilitator. There were total 8 notified diseases under the Mines Act. Now here there are total 29 diseases notified under 3rd schedule under Occupational Safety Health Working Condition Code. There in Mines Act, the medical practitioner, if he fails to comply with the provisions of the Act, he was punishable with a fine of ₹50. Now under the OSH Code, medical practitioner, if he fails to comply with the provisions of the sections of the code, he is punishable with the penalty which may extend up to 10,000. Now we'll discuss the definitions. As per the OSH Code. As per Section 2(1)(c), agent means every person, whether appointed as such or not, who is acting or purporting to act on behalf of the owner, takes part in the management, control, supervision or direction of such mine or of any part thereof is called as an agent. Appropriate government, Section 2(1)(d). CPSU or subsidiary setup including establishment of contractors for the purpose of such establishment. Central government, even if it is holdings or central government, reduces to less than 50%. And for factories, it is mentioned for factories, it is a state government. Appropriate government is state government. Under Section 2(1)(h), building and other constructions. The construction alteration, what is building and other construction work means? The construction, alteration, repair, maintenance or demolition in relation to building, building and everything, transmission, powers, towers, radios, television, etc. But does not include buildings or other construction work which are related to any factory or mine. That means the constructions which are in mines made do not come under this definition. As per 2(1), competent person. The competent person includes such other person who is authorized by the manager to supervise or perform any work or to supervise the operation of machinery, plant or equipment and is responsible for such duties assigned to him, and also include a shot firer or a blaster. There is not much change in the definition of competent person. The new inclusion is 2(1)(m), that is contract labor. The worker, contract labor is a worker employed in or in connection with work of an establishment when he is hired through a contractor, but it does not include a person who is regularly employed by a contractor. Matlab, any person employed in a mine through a contractor, then he is called a contract labor. 21N. Who is contractor? In relation to establishment means a person who undertakes to produce a given result from the for the establishment other than a mere supply of goods or articles of manufacture to such establishment through contract labor, or one who supplies contract labor and also includes a subcontractor. Means a contractor is a person who delivers, produces, gives results to the establishment, and also he is a person who supplies contract labor to the establishment, and also it includes a subcontractor also. Establishment. Establishment is, yep, sir. If it defines establishment if that any establishment if 10 or more workers are employed therein. But in case of mine, it is not mentioned here. Mine is called an establishment. There is no restriction of 10 persons to be employed in a mine as per definition. Factory is as if any power is used, then if there are 20 persons are employed, and for factory it is definition is that if without any aid of power, if 40 persons are employed are there. Manufacturing process means what? As per 21 ZI. Any process for making, alteration, repair, ornamenting, finishing, packaging, oiling, washing, cleaning, pumping, generation, transformation, transmitting of power is called as a manufacturer. Who is employer? As far as mines is the owner of the mine, agent or manager of the mine is an employer. Chief inspector cum facilitator is a person who is appointed by the appropriate government under subsection 5 of section 34. And this is a new inclusion, interstate migrant worker, section 21 ZF. Interstate migrant worker is a person recruited directly by employer or contractor in one state and establishment in another state. Means what is that if a company, if a person, a contractor or any company recruit a person from in one state and he is posted, but he has to work in another state. If the establishment is another state, then that person is called an interstate migrant worker. Or else, if he comes on his own from one state to the other state and subsequently changed the establishment in the destination state and not earn more than 18,000 per month or higher amount as notified by the central government. That is, in two cases we can define him as a interstate migrant worker. One is he can buy employer or establishment or a contractor will recruit him and post him to work in another state. Second thing is he can come on his own and work in any establishment, but he should not earn more than 80,000 per month. Then he is called as interstate. He is defined as interstate migrant worker. Now, core activity is defined as per 21P. Any activity for which the establishment is set up, including any activity which is essential or necessary for such activity. Means any activity of an establishment is set up includes any activity which is essential necessary to such activity, provides that the following shall not consider as essential or necessary activity if the establishment is not set up for such activity. Means core function for which the establishment is established, that is considered as core function, but not include sanitary work, sweeping, cleaning, security, canteen, etc. Or any other civil works, lawn, gardening, transportation, everything will not come under core activities. What is an industry? Defined in 21ZD. Means any systematic activity carried out by cooperation between an employer and a worker for production, supply or distribution of goods and services with the view to satisfy human wants or wishes. Means any industry means any activity that is done by between the mutual cooperation between the owner and the worker to produce anything or to supply or distribute any goods for human needs, for satisfying human needs. And this comes our definition, section 2(1)(z). It is mine. You see, there is no major definition changes as per Act. What was there, the same thing is there. Mine means an excavation where an operation for the purpose of searching for or obtaining minerals has been and is being carried out on includes boreholes, oil wells, shafts, inclines, etc. Open cast working, conveyors, aerial ropeways, lights, so siding, workshops, stores, power station, transformers, substation, rectifier stations for supply electricity solely or mainly for the purpose of working in the mines. Number of mines under the same management. Premises in which dressing or preparation of for sales of minerals or coke is carried. Who is an employer as per section 2(1)(u) means in relation to factory is the occupier of the factory. In relation to the mine, the employer is owner, agent or manager. And for contract labor, it is contractor. 2(1)(z). Occupier. Occupier is a term used for the factories, person who holds ultimate control on the farm or the factory. Owner. 2(1)(zw). In relation to a mine means a person who is immediate operator or lessee or occupier of mine or of any part thereof, but does not include a person who is merely owner of soil and not interested in the mineral of the mine. But any contractor or subleasee for the working of the mine or any part thereof shall be subject to the code in like manner of he was an owner, but not so to exempt the former for any liability. See, the definition is same. The owner is the person who holds the, as Mines Act 1952, as per the terms of the Mines Act. Then who is called principal employer? The principal employer in case of mines, he is the owner or agent. Now here the manager doesn't come. Principal employer in case of contract labor is employed in a mine, then in owner or agent is the principal employer when mining is concerned. And who is an employee? As per 2(1)(t) means a person employed on wages by an establishment to do skilled, semi-skilled, unskilled, manual, operation, supervisory, managerial, administrative, technical, clerical, etc. in case of a mine. Means whoever person employed in a mine is called an employee, whether he is a manager or a skilled worker or an unskilled worker. All are defined as an employee. A person employed in a mine who works as the manager or who works under appointment by the owner and agent or manager of the mine or which knowledge of manager in any mining operation. In operation, services related to development including construction of plant therein, but excluding construction of building, roads, wells and any building workings directly connected, not directly connected with any existing or future mining operation. Means the persons who are employed in other development works which are not directly connected with the mining, they won't come under employees. Services, maintenance or repair of the machine, he comes in operations, loading of dispatching within the premises, he comes. If any office of the mine, it comes. 2(1)(z)(i) worker. Employee, who is a worker? Employed to do any manual, unskilled, technical, operation, clerical or supervisory work for hire or reward, but does not include a person employed in managerial or administrative capacity or employed in a supervisor capacity drawing wages exceeding 18,000 per month. Means the worker means the person below supervisor, it may be in simple terms it can be called, who is not involved in administration or management and supervision, and he earns less than 18,000 per month. And a week, what is a week? The same definition which is starting at beginning of midnight of Saturday night. Now wages, here he says wages includes basic pay plus DA plus retaining allowances. For any employee, the wages includes basic pay plus DA plus retaining allowances, but does not include bonus, house accommodation plus light, water, medical, PF, pension, contribution, conveyance allowance, ex gratia, etc. What are the additional benefits are given that are not included in wages? Now this is the main part, registration part. After coming into force of this code, as per section 3.1, employer of every establishment shall within 60 days apply electronically to registering officer appointed by the appropriate government for registration of such establishment. Means every establishment should be registered electronically within the 60 days of coming into this force. Yes. Containing such particulars including the information related to the employment of interstate migrant workers. Here more importance is given to the interstate migrant workers, contractor laborers, which were these workers were neglected earlier. Neglected means provisions were not there in Mines Act. Now they are incorporated in this code. Now, in case of any change in the ownership of the management changes, the employer should immediately inform the such registering officer within 30 days of any such change electronically. Now onwards, anything that is done, it has to be done electronically only. If employer of an establishment shall within 30 days of closing of the establishment shall inform the closing of such establishment with a certificate payment of all the dues to workers employed. If my establishment is being started, he has to register electronically. If the ownership is changed, he has to change the ownership electronically. If the establishment is closed, he has to submit the details to the concerned officers. The registering officer, who shall within 60 days period, 6 days period, cancel the registration certificate of such establishment. If an establishment is approaching a registering officer that I am going to close my establishment, then within 6 days he has to cancel the establishment. Here in a code, all the provision is there. These all are time bound. If an employer registers, what happens? The registering officer should allot in a specified period his certificate. If it is not done within that period, it is auto-generated. So the system will be auto-generated. The establishment is registered automatically. There is a provision in this. And no establishment should work as per section 3.7 without registration. No registration, no employment. Simple. Now let us come to go to the brief of what are the duties of employer. Duties of employer. Every employer, he should see that the workplace is free of hazard, which may cause injury to the and occupational disease, and comply with the occupational safety health standards. Provide an annual health examination or test at free of cost. Every employer should provide annual health examination at free of cost. Provide the working environment that is safe and without risk to the health of the workers, health of the employees. Ensure the disposal of hazardous and toxic waste, including disposal of e-waste. Issue a letter of appointment to every employee. You see, this is most important. Issue a letter of employment to every employee. It is a duty of the employer. As duty of the employer, who is employer? We have seen already. Employer is all the three in respect to the mine: owner, agent, and manager. Relating to the factory, mine, dock work, building, and other construction work or plantation, ensure and be responsible for the safety and health of employees, workers, and other persons who are on the work premises of the employer. So it is the sole responsibility of the responsibility of the duty of the employer to see that the workplace is free of all the risk hazards and the workplace is safe and it will not contract any occupational disease to the worker who are employed in the premises. Duties and responsibilities of owner, agent, of manager in relation to a mine. More or less the duties are same. That once again, let us see. The owner and agent shall jointly and severally be responsible for making financial and other provisions and for taking such other steps necessary for compliance of OSH code or regulation or anything, any rule, regulation, order made thereunder. Owner or agent are responsible for providing financial assistance or any other steps taken to comply the OSH code. In the event of any contravention by any person, unless the person has used due diligence to secure compliance with the provisions and had taken reasonable means to prevent such contraventions, he will be deemed as guilty. Means any contravention has been done under this code, then he is deemed to be guilty. He has not used all his diligence. The official or officials appointed to perform duties for supervisors in respect of provisions contravened. The manager of the mine, the owner and agent of the mine, the person appointed, if any, to carry out reasonable under section 24. Now, here it included duties of manufacturer, designer, importer and supplier. And this is a new inclusion in our code. Earlier, this was not a part of our Act 1952. Now it has been included. Duties of a manufacturer, designer, importer and supplier. What is that is, he has to ensure that reasonable practicable the article is so designed and constructed in the establishment to be safe and without risk to the health of the workers when properly used. Means the person who has manufactured, designed, imported or supplied any article to any establishment, he should see that the article is safe and it should not cause any risk to the health of the workers employed therein. And he should carry out examination to find out it is fit and effective for implementation of provisions of the clause A. And he should ensure that information is connected to this article or whatever thing he supplies to the establishment is available at the office. How to use it, how to maintain it, everything regarding the article. If an article is designed, manufactured outside the India, then it shall be obligatory on the part of the importer to see. That means any article or machinery or anything which has been manufactured outside the India, then the article should conform to the same standards of such article manufactured in India. If the standards adopted in the country outside the India for the manufacturing of such articles is above the standards adopted in India, that the article conforms to such standards in such country. Means if any article is prepared or manufactured in outside the India, then if that standards are higher than the standards set in India, then it can considered as article conforms to the standards of that country and our country also. Now here notice of accidents are to be given by the employer in case of death, in case of any bodily injury by reason for which a person injured is prevented from working for a period of 48 hours or more immediately following the accident. Means it is the duty of the employer, owner, agent of a manager or a manager, he has to inform whenever in an establishment an accident occurs which causes death or which causes any bodily injury, by any reason, so which makes a person to absent from his duty for more than 48 hours. The employer or manager in relation to such establishment, if it is a factory, and for us we know it is a employer, owner, agent or manager of the mine should inform to the concerned officers, and that notice thereof shall to such authorities in such manner and within such time as may be prescribed by the appropriate government. Means the forms, the methods, and to whom it has to be submitted will be prescribed by the appropriate government. If any dangerous occurrence occur, as per section 11, shall send notice thereof to the authorities in such manner and within such time as may be prescribed by the appropriate government. Notices of certain diseases specified in 3rd schedule shall send notice thereof of such authority to such authorities in such manner and within such time as may be prescribed by the appropriate government. Everything will be in detail will be elaborated by the appropriate government. But in all these 3 cases, in any accident, loss of life, serious injuries causing 48 hours of absence, or any dangerous occurrence, or any notified disease contracted, any person contracted notified disease, all these things to be informed to the appropriate authority. And here duties of employees are rights and duties of employees are defined. Every employee take reasonable care for the health and safety of himself and of other persons. Comply with the safety and health requirements. Cooperate with the employer in meeting the statutory obligation of the employer. If any situation which is unsafe or unhealthy comes to his attention, report the situation to the agent or manager and safety officer or official for his workplace or section. Not willfully interfere or not willfully endanger himself or others. These are the duties of an employee. No person shall intentionally or recklessly interfere with, damage or misuse anything which is provided in the interest of health or safety of or welfare under this code. Means employee must should not willfully or negligently do anything which may cause danger to the health and safety of himself as well as the persons working along with him. And he should cooperate with the owner to comply the statutory obligations. These are the rights and duties of an employee. Occupational safety and health. 16.1. The central government shall, by notification, constitute National Occupational Safety and Health Advisory Board. Herein, the code referred to be National Board. So this is the most important thing. Now, as per section 16, the central government by notification constitute a National Occupational Safety and Health Advisory Board. Thus refer to National Board to discharge and functions conferred on it by under this code and to advise the central government on matters relating to like standards, rules, regulations to be declared or framed under this code. National Board will suggest or will guide central government in making the standards, national standards, rules, regulations, anything framed under the code, and also help in implementation of the provisions of this code and the standard rules, regulations, etc. So these are going to be, National Board is going to play a big role. The National Board, in the National Board, the Secretary Ministry of Labor and Employment will be the chairperson ex officio. Under him, this board is constituted. And one of the member will be the Director General of Mine Safety, Chief Inspector of Mines. And similarly, all other departments, explosive, pollution control board, members will be from different departments. And 5 persons connected with the field of occupational safety and health. Representative from the research institution will also be the member. Representative for professional bodies associated with the matter to which standards, rules, policies being framed member will be there. Special invitees from the state government or the government of union to give inputs can be made a member. Like this National Board is now plays a very key role in formulation and implementation of the board. Now, Safety Committee. Under Act 12, Safety Committee was formulated. Now here in the section 22, of OSH code, Constitution of Safety Committee as prescribed by the appropriate government. In every establishment, when it is a factory, 500 workers or more. If in a building or construction work, if 250 workers or more. When it comes to a mine, if 100 workers or more are ordinarily employed, then a safety committee should be formulated. The employer shall appoint such number of safety officers who shall possess such qualification and perform such duties as may be prescribed by the appropriate government. The appointment of safety officers and officers for ensuring safety in the mines will be declared by the appropriate government later. Now, health, safety and working conditions. Section 23 says that the employer is responsible to maintain in his establishment such healthy, safety and working condition for the employees as may be prescribed by the central government. In matters like cleanliness, ventilation, temperature and humidity, environment free from dust, noxious gases, fumes and other impurities, adequate standard of humidification artificially increasing the humidity, install potable drinking water, adequate standards to prevent overcrowding, adequate lighting, and provision of latrines and urinals, accommodation to males and females and transgenders employed separately, and maintain hygienic area. Effective arrangements for treatment of waste and effluent, and any other arrangements with the central government consider appropriate. The welfare provisions should be provided by the employer at the establishment as prescribed by the central government. For washing, for bathing places, they should provide a canteen if more than 100 persons are ordinarily employed in a mine, including the contract labour. In case of mines, medical examination of the employed are to be employed in the mine before their employment at specific intervals. This was same aspect. And we have to provide adequate first aid boxes or cupboards containing readily accessible during all working hours, ambulance, if 500 or more persons are employed. We have to provide an ambulance room if ordinarily 500 members are employed. Welfare officers should be provided when 250 persons or more workers are ordinarily employed. Crèche should be provided for children below 6 years for more than if more than 50 workers are employed. Now, hours of work. Hours of work is more or less same, but it is stated that appropriate government will notify for workings below ground, for workings in the mine, and what should be the duration, how much should be the time interval between the working hours. But it generally says no worker shall require to allow to work in any establishment or class of establishment for more than 8 hours in a day. Okay. Now this is transport workers' timings. It is not much required for us. Hours of work 26. No worker should be allowed to work in establishment for more than 6 days in any one week. If he has been deprived of compulsory day of rest, the subsequent number of compulsory day of rest should be given in the same month or successive 2 months. Overtime. If any workers work for overtime, the employer has to pay twice the rate of subject to consent of the worker of such work. Means overtime cannot be extracted forcibly. We can make him to work. It has to be accepted by the worker, and if he works, we have to give double the wages. Restriction of double employment in the factory or a mine. This was in Mines Act also. We should not employ any worker in a mine if he is employed in any other mine for the preceding 12 hours before the employment of the person in the particular mine. Leave with wages. The leave with wages, the worker is entitled if he has worked for at least 180 days or more in a calendar year, and entitled for 1 day of leave for every 20 days of work. And if an adolescent is employed it will be at the rate of 1 day for every 15 days. And if a worker works in below ground, it will be at the rate of 1 day for every 15 days. And the earned leave can be carried forward, not exceeding 30 days to such succeeding year. Means from 1 year to another year, he can carry only 30 ELs. The rest years exceeding 30 ELs, he can encash. Now, any mine or any office, maintenance of registered records and returns. As per section 33, an employer shall maintain particulars of workers, work performed by them. These registers particularly should be maintained in the mine, the work performed by them, number of hours they have worked, day of rest, wages received, OT attendance, dangerous occurrence, employment of adolescents, daily notices, file returns electronically in a manner prescribed by the appropriate government to the inspector cum facilitator. All these registers are to be maintained by the employer. Now, inspector cum facilitator. Inspector cum facilitator is appointed to conduct inquiry into the accident, dangerous occurrence, or make any inspections in the mines to enforce the OSH code. Now, as per section 38B, special powers in respect of mines, the inspector cum facilitator can issue notices if in dangers for which no express provision is existed. He can issue probity order if the employer fails to comply the notice. To issue notice danger for which express provisions exist under the code. To issue probity order if employer fails to comply the notice. Means it is similar to what is mentioned in the Mines Act. As per Mines Act, if express provisions provided or not provided, if inspector is in opinion that there is an immediate and urgent danger to the workers employed therein, he can issue notice or order, respectively as per powers given under respective sections. Here also the same powers are there. The inspector, if he feels, then he can impose order or notice, depending upon the justification he has. Provided that if any employer, if he feels that the notice given or order given, it is not what we say, if he is deprived of something or if he is not satisfied with the order given, he can appeal to the chief inspector within 10 days and to the central government within 1 month of issue of such notice or order. Now there are, as per section 43, there are special provisions relating to the employment of women. Now you see, it is a big step in mining industry especially. It has come in an act, code, that women shall be entitled to be employed in all establishments for all types of work. You see, for all types of work under this code. That means there is no discrimination in the type of work which has been done by the males. This can be done by the females also now onwards. And they may also be employed with their consent before 6 a.m. and beyond 7 p.m. subject to such conditions relating to safety, holiday and working hours or any other conditions to be observed by the employer as may be prescribed by the appropriate government. Appropriate government may require employer to provide adequate safety prior to the employment of women for such operations where employment of women is dangerous for healthy and safety. This is government should see can enforce an employer to provide all the safety provisions, safety requirements for a woman if employed in a working place. Special provisions for contract labor. This is very much important thing. One of our earlier speaker also expressed his humanitarian grounds. We all see about the contract laborers, migrant workers. Now they have got a say in this code. As per section 45, this part says that every establishment with 50 or more contract laborers are employed or were employed in a day of the preceding 12 months through contract. Means this provision will apply if 50 persons are employed in any establishment through a contract, or every manpower supply contractor who has employed or any day or on any day for preceding 12 months 50 or more contract laborers. These provisions will attract. This part shall not apply to the establishment in which work only of an intermittent or casual nature. If any work is of intermittent nature, these provisions won't attract. But if intermittent work prolonged for more than 120 days, then it is applicable. And if it is also of seasonal character and performs more than 60 days in a year. In these two cases, the work is of intermittent nature also, the provisions of the code will attract. Now, for special provision for contract labor, that is, now a license is to be taken by every contractor for deploying any person in any establishment. If the contractor does not possess any license, issued under section 42, he cannot deploy the workers in any establishment. If an establishment engages in a contractor who do not possess the license, then that establishment is at fault. That is, it is contraventions of this code. So now onwards, whenever a management tries to employ a contractor for any work, it has to check whether that contractor possesses license issued under this code, which is a very much important thing. And this license is valid for 5 years depending upon the number of contract laborers and nature of work. While obtaining the license, the contractor should specify the number of employees, contract laborers he will employ, and what type of work he will do, and so on. If you want to change the nature of work, or if you want to increase the number of labor, again he has to apply to the appropriate authority and get the license renewed if any changes are there. And this is a very good thing which has been incorporated in this code. Now, as per section 53, welfare facilities should be provided to the work persons. It is a duty of the principal employer of the establishment. Principal employers shall employ contract labor for license holder. Like payment is a very important thing. Payment of wages is the responsibility of the contractor. He should distribute the payment or wages through bank or electronic mode or any other mode which is appropriate government prescribed. But in case of any payment, if contract doesn't make to the contract labor, now it will be the liability on the principal employer to make that payment. That means if a contractor doesn't pay to the contract labor, the principal employer, it will become the liability of the principal employer. He has to pay. Then he can deduct from the payment which has to be made to the contractor in any means. Central government can also authorize to deduct the amount from the security deposit which the contract labor deposited with the establishment. Recover from the security deposit also. There is a provision given to central government. Special provision, the contract labor in core activities. This is also an important thing. The core activities which were defined earlier. The core activity is the main activity of any establishment. In that any activity, the contract laborers cannot be deployed. But there is a relaxation that in any case, if the normal functioning of the establishment in such that the activity is ordinarily done through contractors, or full-time engagement of workers is not required, or any sudden increase of the volume of the work needed in specific time to meet the demands, then in these three cases, the contract labor can be employed in the core function of any organization, or else they cannot employ. And if a doubt arises whether this is the core function or not, whether here the contract laborers can be employed or not, it can be, if any dispute arises, then it can be submitted to the authorized officer by the central government. Then his decision will be taken into whether this is a core activity or not, whether their contract labors can be deployed or not, will be finalized. When it is come to a mine, the same things are there as per Mines Act. No much changes is there. The mine should be kept under a mines manager, okay, for management, control, and direction of the mine. And no other person should give directions to the work persons, only in cases of emergencies, okay, where the manager should be responsible for his carrying out the OSH code. The provision of this code, except that contained in the section 35, 38, 40, 41, 44, shall not apply to a mine. Means there are exemption to a mine or part prospecting, like number of persons. If any mine or a part prospecting purpose only and not for the sale, employee, depth or excavation type of mineral as prescribed by the central government. Means there was exemption in the section 3 of the Mines Act 1952 also for certain cases, certain minor minerals for less than 6 meters of excavation, and number of employees in case of less than 20 or underground mines, like this there, that was there. They were not coming under the purview of the Mines Act. Now all these things will be prescribed by the central government in later. And in a mine, there should not be any employment below 18 years as previously, and an apprentice should not be employed below 6 years. Now this practice is not related to us. Now this is the major changes in the penalty. If for any offences, the penalties are increased. Earlier, as per Mines Act, it was meager. Now if you see as per section 94, if contravention of provisions of code, regulations or rules or bylaws or standards or orders made under this code are contravened, penalty may lay up to 2 to 3 lakhs and thereafter 2,000 per day. And the penalty will be on the employer or principal employer. For contraventions under this code, the penalty may be up to 2 lakhs, can extend up to 3 lakhs, and thereafter, if the contravention is continuous nature, it will be penalized 2,000 per day. And who will be responsible? Employer or principal employer. If, as per section 95, any obstruction to the chief inspector or inspector in discharging his duties, if any person obstruct or inspector or chief inspector in discharging his duties, the fine penalty will be up to rupees 1 lakh. Or imprisoned with 3 months, or both. He can get both penalty, he will get 1 lakh or 3 months imprisonment, or both in this case. If the same offence is repeated, this will be doubled. The imprisonment will be 6 months, and the fine will be 1 lakh to 2 lakhs, or both. The fine can be increased up to 2 lakhs, double. The punishment will be doubled. If any person fails to maintain registers or documents or files or returns, the fine will be 50,000 to 1 lakh, and if it is repeated, then the penalty will be increased to 2 lakhs to 1 lakh to 2 lakhs. Contravention of provisions regarding deployment of women contractor laborers aged below 18 years, then the penalty will be 50,000 to 1 lakh. If repeated offences there, the imprisonment will be there for 3 months, and penalty will be increased to 2 lakhs. If anybody make a falsification of records as per section 98, the rupees 1 lakh, the penalty will be rupees 1 lakh or imprisonment of 3 months, or both, to any person. If any person omits to make a furnish a prescribed format, plan, section, reports, etc., the penalty will be between 1 lakh and 2 lakhs. Disclosure of information. Disclosure of information is that in the time of inquiry or anything, any confidential information gathered from the establishment, then it has to be kept confidential. If it is leaked out in public domain or some other process, then it is also a penalty is imposed up to 1 lakh or imprisonment up to 3 months. For in this case, it comes to the inspectors. Wrong disclosure of analysis result. The penalty can be 50,000 and 3 months imprisonment or both. As per section 102, it fails to contraventions of provisions relating to hazardous process. Contraventions to hazardous process means there where there is a threat to life and health. The rupees 5 lakhs, penalty is rupees 5 lakhs or 2 years imprisonment, both. Thereafter 50,000 per day. If the contravention exists, after that also, then it is 50,000 per day. If it is exceeds period beyond 1 year after date of conviction, means in any case it has been proved that there is a contravention, hazardous contravention, this penalty is up to 20 lakhs or 3 years imprisonment or both whatsoever. You see, now the contravention itself can lay a penalty up to 20 lakhs. Many folds, it has increased many folds. Contravention of provisions or code, regulation, rules, bylaws, standard results into an accident or dangerous occurrence. Earlier one, no need, if no accident, if it is a contravention, penalty is up to 20 lakhs. Now, in case any accident occurs or dangerous occurrence occurs, for death, it is, if any death occurs, the penalty is 2 lakhs, imprisonment is 2 years. If any serious body injury is happened, then penalty ranges from 2 lakhs to 4 lakhs and imprisonment up to 1 year or both. In both the cases, either or both. And the 50% of the amount to be given to the victim or the dependents of the victim. It is a very good thing has come in this act. And if offence is repeated, same time of offence is repeated, the punishment again doubles. In this case also. Contravention of order issued under Regulation 38. If any order is issued and if it is contravened, then the penalty is rupees 55 lakhs and imprisonment up to 2 years. Either or. Fails to appoint a manager. If any owner fails to appoint a manager, the fine is up to 1 lakh and imprisonment up to 3 months or both. Now, the contravention of provisions by employee. If employee also contravene any provisions of this code, given duties and responsibilities of the employee, he has to pay a penalty of 10,000 rupees by the concerned employer. And then, as per section 107, it says that no prosecution under the code of owner, agent or manager for any offence under this code except the instance of chief inspector cum facilitator or DM or inspector cum facilitator. In case of technical nature, DM shall not institute any prosecution without previous approval of chief inspector cum facilitator. These are the main concepts. This miscellaneous, as per this miscellaneous part comes, the contractor can take or any establishment get licenses, 2 to 3 licenses under one name only. As per section 134, central government can make rules. Section 135 give power to state government to make rules. Section 136 gives the central government to powers to make the regulations. Section 143 states that anything done or any action taken under the enactment of such so repealed, including any rule, regulation, bylaw, notification, nomination, appointment, order or direction made thereunder, shall be deemed to have been done or taken under the correspondence provisions of this code and shall remain in force to the extent they are not contrary to the provisions of this code till they are repealed by the central government. What if just is that now every act, rules, bylaws, every rules, regulation, bylaws will be framed under this code, and from the date on which enactment they will come into force, and all the previous respective previous regulations or rules or regulations will be repealed. That is mentioned in the. This completes our OSH code. Now, we'll throw a little light on the rules. The central government has proposed Occupational Safety, Health and Working Conditions Central Rules 2020, from which now only we have studied under section. They have got powers under section 133 and section 134 of the.
Please.
You see, this is in a public domain, Now it was all these rules. I think you might be seeing the mine rules, rescue rules, occasional rules. All will be subsumed into one rule. And you see, it was notified. I think on November this 2020, and given 45 days time to give your opinion. So every member in the meeting or any concerned party, any objections or suggestions, any stakeholders can give their suggestion to Sri Shivakant Kumar, Under Secretary. Okay, it is mentioned in the notification only. You can submit there. Now, this is an important thing, disclaimer I want to make. This presentation has attempted to throw a light on the provisions concerned to the operation of mines only. Based on the information, data, documents available in the public domain and is personal opinion, interpretation of other, and thus do not stand any legality. I will make it clear, this whatever I have said or our director said, it is our personal opinion and does not possess any legality. Okay. The bill for labor code has already been passed in both the houses, and it will come into enactment from the date from which it is notified by the central government. I thank you all for your patience hearing. And also MEAI for giving my opportunity. Thank you.
Sir, thank you very much, sir. So, for your elaborate and in detail presentation, it is very enlightening for almost all the participants, because so many issues are there, but there are so many doubts also there. But the time which we have, I think it will be difficult to clarify. But still, we can try to clarify as much as possible. So I have one doubt, sir. This regarding appointment letter for every employee, whether it's a contractor employee or a department employee. So who will give the employment this appointment letter, sir, for contractual employee?
Employer. It is mentioned the employer only. Every
employer has to give the contractual.
Is it principal employer or the contractor? He is the employee of the contractor.
Now you see, not for now it has become an obligation for the employer not only to give the letter of appointment, but also what we say, all the provisions, safety, welfare provisions to be provided.
No, sir. Yeah. Now the contractor is also defined as the employer now. Now contractor employment appointment letter to his employee is sufficient, or principal employer has to give something else?
See, Reddy sir, the contractor, the license holder, who is the license holder, registered license holder, he has to give appointment order to that person, where that person is employed. Okay. And the binding document will be there for occupier as well as the contractor. Okay.
Fine, sir. So thank you, sir. Yeah. Sir, some more questions also are there.
And one more bit it was missed. I like to say there is in this code the Social Security Fund is established, but it is not defined very concretely. And this Social Security Fund, this is drawn from the penalties imposed under section 114. Okay. This modality for this Social Security Fund, it has to be made. It is not made right now. Okay. This is also one of the aspects. Another aspect is every interstate migrant worker are identified by the Aadhaar. Okay. Whenever they migrate from one state to another state, the contractor has to absorb in his electronic data sheet. So every contract labor is identified by the Aadhaar mode, and his elsewhere employment and earlier employment, everything will come into picture. This is one of the things which is made unique in this code. This accountability of each and every interstate migrant worker. It's identification as well as accountability.
Thank you, sir. Vidyarthi sir, you want to ask something?
Yeah, I just have one doubt. It was an excellent and very elaborate presentation. As per section 105, it says the penalty is 5 lakhs or imprisonment of 2 years for failure of employer to employ a manager. Now, my one simple doubt is that for past 3 years, no examinations are conducted. There is an acute shortage of managers in the field. What do we do in this case? Naturally, employers will not have enough managers. So whose failure it is?
Pardon, you cannot get you. What do you want to ask?
So just asking about
Section 105.
105. Yeah, I'm just repeating it. 1 minute, I increase the volume.
105. Section 105.
Yeah.
Where
Penalty to employ and manage.
punishable for 3 months or the fine extent up to 5 lakh rupees for the contravention. Section 67. Is it? No?
That's right. Now, my question is that for past 3 years, examinations have not been conducted. So there is an acute shortage of managers. How do you account for that?
Already previous webinar also stated, already notification has come. There were some technical issues were involved. Okay.
That notification has come now. But the fact is of past years, there has been an acute shortage of managers. How do you do that? How do you account for it?
And added to that, sir, one more. Sir, can I add something to that? So you say there is a provision for any misinformation submitted to the department. There is a penalty of 1 lakh and more. So what is that misinformation? Maybe some topographical error or some small issues. So they may be considered as a misinformation also. So how to deal with that, sir? Well, probably.
Any misinformation is
any minor mistakes, yeah.
Minor mistakes, it won't be the thing, but whatever comes in the code, whatever in contrary to the code, the information submitted for compliance of the code, then it will be considered.
Yeah, that is true, sir. But it depends upon the interpretation.
See,
So any discretion of the officer who use it.
Any unintentional acts of omission commission during the day-to-day working, it will be considered. And usually the subjected to legal scrutiny and other aspects which will have a greater ramifications. And for that, this clause will apply. For that, even the court has to decide whether for the conclusive. Okay.
So, thank you, sir. Sir, still we have a lot of questions, sir. In the chat box, some questions are there. I think now it's already 12:52. So, shall we share the questions to you later, sir? So, you said you want to, So, we can share the questions. Please go ahead, sir.
Yeah, Dhanesh, sir, whatever the questions arise from the participants and whatever of its nature, you collect the question and will give a reply to it. Okay. Because the subject is very vast and it took almost 4 years to frame this code, and questions will be very big. I know it.
Yes, sir. Yeah.
Because of intricacies are involved and working intricacy as well as there is a particular situation and many things will come into picture. Okay. We'll address maximum questions and you based upon this you raise all the questions to this office. We'll answer them. Okay. We'll officially answer them.
Sure, sir. Definitely, sir. Because our next speaker, Mr. Vijay Singh, also having a lot of doubts and questions in this. So I think everything we will put up to you, sir. So that we can answer and later we can send it to all the participants also. I think that will be fair because now since already we are late with our scheduled time. So I think we'll do like that, sir.
Okay, sir. Okay. Thank you.
thank you, sir. Thank you very much.
Thank you.
So, sir, and Mr. Venugopal, sir, you have taken a lot of pains in presenting this paper. I thank you very much. Now I request Mr. V.A. Singh. So I think now he is left.
I think I was saying whether it applies to whole of India. Somehow the lawmakers are silent, so they should definitely come up with something at the earliest. They should come up with an ordinance, otherwise this is open to challenge. Why I'm saying so? Because the other three codes, it clearly says it applies to India, whereas only in this OSH code they are silent. Now if you go to the old act, it clearly says it applies to India, but somehow this code is silent. Now if you go to the draft rules also, it says applies to India, but somehow the code they are silent. Okay, now moving on. Now it shall come into force on the date it is notified. Now the old law says there is a deadline given in the old act. Mines Act 1952 clearly said each provision should be notified by 31st December 1953. They had a period of roughly 1.5 years to ensure that all the provisions were notified. But somehow the code is silent. So we don't know when. It is up to the government as to when they can notify. Now, draft OSH rules, it supersedes 5 pieces of legislation. It's nothing but the mines rules, it supersedes mines rules, rescue rules, official training rules, pit and bath rules, and the mines fish rules. But now the issue is what will happen to MEAI, Metal Ferrous Mines Regulations, that's silent. No, I think the government will come up with something, maybe some other rule or some other regulations or some notifications going forward. But as of now, they're silent as to what will happen to MEAI 1961. We also have another piece of legislation called Ease of Compliance to Maintain Registers under the various labor laws rules 2017. What will happen to this? Now, if you see, they have done away with B-Register. Earlier, B-Register was popular from 2017. They merged this B-Register. They clearly said, Form B, C, D and E, everything they merged and brought. They said you have to do everything Form A or Form D. Like that, they amalgamated some forms by way of this compliance rules 2017. But now what will happen to this? Nobody knows. Maybe even this rule should get repealed whenever the code is implemented. Now, look at the way they drafted the rules. Just a small trailer. They clearly say Rule 2.2, the words and expressions used in these rules and are not defined therein, but are not in the code. Ideally, they should have said, but are in the code. Somehow there is a drafting error. They are saying, but are not in the code, shall have respectively meaning assigned to them in the code. Now, when there is no definition in the rules, I can't even go to the code by virtue of this, the entry here. I can't even go to the code, so I have to fall back on the dictionary meaning. I think they need to do changes like this. So they have to look into the way the rules are drafted. Now, if you go to the Act, we have 143 sections and we have 3 schedules. The first schedule, the second schedule and the third schedule. Now, if you go to the rules, even the rules have schedules. Now, there are no schedules at the end of the rules, the draft rules. But there is a schedule inbuilt into the rules itself. Now, if you go to Rule 83, something they are talking about dangerous occurrence. In the rule itself, they have given the schedule. Similarly, if you go to Rule 114, the draft rules, it talks about rescue station, rescue room and so many other things. They are talking about Schedule 1, 2, 3 and up to Schedule number 8. Somehow they have missed out notifying Schedule number 5. What is Schedule number 5? Nobody knows. And how the schedules are going to be there, that is yet to be put in the public domain. So we have to wait and watch. Now coming back to the code, now already the earlier speakers have said, this is not applicable to the offices of the central government or offices of the state government on any ship or war of any nationality. But if those central government or state government, if they employ contract labor, then this code will get applied. So that means any office of Vidhan Sauda, RTO, some of these offices, this code is not applicable. Now the questions that everybody should ask is whether this code applies to DGMS offices. Yes, according to me, for DGMS as an establishment, it is not applicable. But as implementing authorities, the code is applicable. Fine, that is how it works. Now, but if the same DGMS, if they have contract labor, then definitely this code is applicable. Moving on, there are some definitions. Adolescent they have defined, which was not there earlier. Now they have defined chief inspector. Earlier it was only inspector. Now it is chief inspector cum facilitator. Now it is inspector cum facilitator. Only time will say how much our inspectors and chief inspectors will become facilitators. Only time will have to tell whether they really indeed become facilitators when we are watching. Now competent persons. I only say competent person includes a short firer. If you see towards the end, I have highlighted in end. In the red color, it says it includes a short firer. But unfortunately, if I go to the explosive rules, they say they have defined who is a short firer. It says short firer means a competent person recognized and certified by the controller for carrying out blasting operations using explosives in areas not coming under the Mines Act 1952. When a short firer does not come under the purview of the Mines Act, now how can the code or even the earlier Mines Act can have short firer as a competent person is a big question mark. So I leave it at this. So coming to the contract labor, already enough has been discussed. Now only one thing on the definition of employer. So the last point if you see, even the manager will be considered as an employer apart from the owner of the mine and the agent. So the managers have to be careful going forward. Now for the first time they have defined a family. They say family, but mind you, family is used in relation to a worker only, not in relation to an employee. In the code, they have deliberately brought in the difference between an employee and a worker. Every worker can be an employee, but not every employee can be a worker. There are subtle differences. We will just to see what is the difference. Now, what is a family? It says a spouse, husband or wife, children, that would dependent and then below 18 years, parents and grandparents, widowed daughter and widowed sister, who are again dependent on the worker. If you clearly see here, sisters and brothers, stepchildren, they are not part of the family. They have defined family. Now, coming to definition of mine, we all know exactly the same. If you go to section 2, 1 ZL, section 2, subsection 1, clause ZL, subclause 12. Subclause 11, 1 to 11 is exactly the same that is there in the Mines Act. But somehow in the code they have brought in subclause 12, wherein they are saying now mine owned by the government. I have a question that means all along till date, mine owned by government was never called as a mine. It was always called as a mine, whether it's owned by the government or not, it was always called as a mine. But I don't know why all of a sudden they woke up, now they've realized that mine owned by the government also should form part of the mine, so they have deliberately introduced. Now, coming to the definition of the owner, on the words that are highlighted in red. It says it does not include a person who merely receives a royalty, rent or fine from the mine, or is merely the proprietor of the mine, subject to any lease grant or license for the working thereof, or is merely the owner of soil, but not interested in the minerals of the mine. But any contractor or sublessee for the working of the mine or any other part shall be subject to this code in like manner as if he was the owner. Now the question is, if I am a person holding a mining lease, can I be somebody who is just receiving royalties? Not possible. The government comes to know of it, your lease is cancelled. When my lease is cancelled, I don't have a mine. When I don't have a mine, there's no question of me being an owner. And there's no question of you catching a contractor or a sublessee. There's no way, sublessee cannot be a lessee, he cannot step into the shoes of the owner. There is a dichotomy between the definition here and the MEAI Act. So coming to other definitions, they have defined what is prescribed. They say if it is anywhere in the code, if you find this prescribed, it has to be prescribed by the rules and not by the regulations of the bylaws. But somehow in the Mines Act, they say if it is prescribed, it has to be prescribed by regulations of bylaws. But somehow the regulations of bylaws are not found in the code. Now, again, that lead to further litigations. Now, principal employer, for the first time they define again. Now, principal employer, I think we only have to see it is only the owner and the agent of a mine. The manager is never considered as a principal employer, but manager will be considered as an employer, not as a principal employer. Now, Moving on, now what is a worker? I told you they have brought in a lot of changes between an employee and a worker. Now, a worker, if an employee is mainly in the managerial administrative capacity, he cannot be considered as a worker. Or if an employee, if he is in the supervision capacity, drawing a salary or wage exceeding 80,000 rupees per month, he also cannot be considered as a worker. So that is the difference between employee and the worker. So we have to be careful because going forward, you will see there are some provisions that is applicable only to the worker and not to an employee. So we need to be careful. So this is the difference between employee and the worker. I will share the screen and the association will pass it on to the participants. You can take a detailed look. Now, if you come to the court, somehow they have forgotten to define what is a reportable injury. They define serious bodily injury, but they have forgotten to include reportable injury. Reasons are not forthcoming. Now, registration. Today, every establishment has to register. Now, when I say establishment, it includes a mine also. You have to register within 60 days. Now, the government wants to earn money. All along, we were indirectly registering all the mines. By and large, will have a LIN now, Labor Identification Number. Even though it is not mentioned in the Act or the rules, the earlier rules, but still we were registering, but we are not paying any fees. But now, everybody has to register, you have to pay some fees. How much is the fees? Nobody knows. Maybe they will notify shortly, it is not mentioned in the rules. Now, they also say, within 7 days of application, if you don't get the registration certificate, it will be deemed to be registered. So mind you, this deemed to be registered and all, it will be only on paper. Practically, it never happens. Because the moment you apply, some shortcomings are observed and the reply is sent to the applicant saying that, boss, these are the shortcomings which is rectified. So this registering within 7 days will remain only on paper. Now, similarly, even if you are closing the establishment, that is a mine, you have to intimate, which is more or less the same. But there is an additional new condition. When you apply, when you intimate, saying that I am going to close the mines or the operations of the mine, you also, apart from giving the application, you also have to give a certificate saying that all dues of the workers employed in such establishment have been taken care. So this is an additional requirement which person has to comply. Then moving on, Section 3.7, it clearly says no employer of an establishment shall employ any employee without registration. So that means if you are not registered, you can't have any employees working for you. So it is mandatory. So what will happen to already registered establishments? You will be transitioned into the new code within 6 months once the date is notified. Now, they are also saying in draft rule, if you go, you have to display the certificate in a hard copy or electronically. Once I get the certificate, I can very well understand, I can take a print, I can paste it in a prominent location. But I don't know how to display it electronically. Should I have a TV screen, always displaying the registration certificate? I really don't know how to display my registration certificate electronically, it's not possible. Now, appeals. Suppose you have some issues against registration, you can always go in an appeal, there will be one appellate authority. But now the question is, I am not happy with the orders of the appellate authority, what do I do? There is no problem for further appeals. Maybe you have to straight away go to the High Court. Moving on, notice of opening, more or less the same, we are all aware. So we have to give 3 notices of opening at the moment. In the core, we have to give an MMR, we also have to give notice of opening under MCTR. 3 forms will go. Now there are, okay. So coming to duties of the employer, Section 6. Now, the earlier speaker, has gone through in depth regarding duties of the employer. But one very, very prominent thing which was not highlighted was, there is something called as Occupational Safety and Health Standards. This is the first time the government is going to introduce something called as OSH standards. Now this will be apart from the code, apart from the rules. You will have some separate notifications wherein they will come up with the standards. So standards for what? For safe working, for operations, for machinery maintenance, etc., etc. So that means going forward, we also have to comply with the standards, mind you. Now, Section 6.1, it talks about annual health checkup free of cost to every employee, but it only talks about employees who are considered who are above 45 years of age. So what will happen to employees below 45 years of age? They are silent. So provisions have to be built in for this. Now, Appointment letter, yes, you have to issue. It's already been discussed. Now, notice of certain incidents. Now, if you see, in case of death of a person in an establishment, in a mine, earlier you were giving notice, you were telephonically informing the inspector, the chief inspector, the district magistrate or the DC or the sub-divisional officer. We were never informing the jurisdictional police in charge. But now they are saying in case of a death, you also have to intimate the officer in charge of the nearest police station, which was not there before. I think innocuously they are introducing this. To me, they are giving one more avenue for the police officers to come and trouble the mine owners or the mine establishments. I think it is not warranted. It is not warranted. Because all along, for the last 70 odd years, we have managed without the intervention of the police officers. I don't know why this is required now. Of course, they are saying only in case of a death. In case of bodily injury and others, the same provisions continue. Now, of course, the earlier speaker spoke about this board, national board, and then state advisory board. Now, what he has not said was, earlier, section 12, we had a committee. Section 12 of the Mines Act 1952 had a committee. Now, the committee, the government, for example, wanted to bring up new rules or new regulations, it was referred to a committee. Or they wanted to come up with something, or there is an issue between the mine owner and the chief inspector, it was referred to the committee. Or for any safety issues, it was referred to the committee. But now, this code has done away with the committee. They are coming up with this national board or the state advisory board. Now, recently, 15th of December 2020, we have seen there is an amendment to Regulation 14 of MMR 1961, wherein, of course, all the people taking exams are very happy because 60 and 60 days have been reduced to 30 and 30 days before you write the examinations. It's a very good move, no doubt. But if you have observed, this amendment ideally in a normal scenario should have been referred to the committee. But the government has not referred to the committee. Government has usurped powers under section 60. They have invoked powers. The government has clearly said they see some potential danger lurking around the corner of an establishment and they felt a need to have more and more first class and second class managers. That is the reason they have done away referring to the committee and they have voluntarily, without referring to the committee, they have issued this amendment, that is MMR Amendment 2020. So of course the board can have admin, technical and advisory committee. The state also can have a state board. Now I have already told about occupational safety standards. So what you will have standards for what? For all this stuff, to deal with hazardous stuff, appraising hazard to employees, blah blah blah. For all these things, there will be standards going forward. Now, according to me, I call it as a solo suit provision, act of solo suit, because they have introduced migrant workers for the first time. Now the government will have database of interstate migrant workers, or the migrant workers can voluntarily register. Even a self-employed migrant worker can voluntarily register on a portal. They go to come up with a portal. Now safety committee, earlier 100, even now, if you have more than 100 or more workers, only you will have a safety committee. Earlier it was 100 or more persons in a mine, but now it is 100 or more workers. So you have to be careful. It is not employees, mind you, it is 100 or more workers. Then only you will have a safety committee. The safety committee will have equal number of representatives of employee and employer and the workers. Now they have to meet once in a month. So I don't know if they keep meeting once in a month, where is the time for the guys to work in the mines? I really don't know. Because it requires a lot of preparations. Because you have to have a meeting. Then after the meeting, you will have action taken report. You will have to see whether the mine management has complied with all the recommendations or not. So I don't know, the guys who are involved in the safety committee, whether they will at all have time to work in the mine, I really don't know. Now, the other more or less, the provisions are the same. I don't want to spend much time. The composition of the safety committee, basically the manager, the chairman and all that stuff, we are aware. Now, they have introduced something called as a workers' representative now. They have done away with workmen inspectors, mind you. Workmen's inspector, what we have seen in the mine rules, they have done away with. Henceforth, it will be a workers' representative. That's the change they have brought in. Now, we will also have safety officers where 100 or more persons are employed. We will also have safety officers. So there will be more opportunities for first class people. It's also mentioned They have also indicated the qualifications of the safety officers. Basically, it's the first class certificate holders, whether it is underground, open cast, coal or metal. Now, the question is, can a manager work as a safety officer? According to me, no. Manager has got different role to play, whereas safety officer has a different role. So, a manager cannot do the roles of both of manager and a safety officer. It will be two distinct officers. Two different persons have to be there. Now, welfare provisions, of course, they have to have, like I told you earlier, you need to have separate bathing places for male, female and transgender employees, which was not there earlier. So, transgender, they have brought in now. Now, canteen facilities, earlier it was more than 250, now they are saying more than 100 workers. That workers include even the contract workers, mind you, here. Now, earlier we had, there was a provision wherein I can have single canteen case in neighboring mines. That's not there now. Earlier, the workers can themselves form a cooperative society and they could have run a canteen. Those provisions are not there now. Now they have brought in something called as ambulance room, wherein more than 500 workers are ordinary employed. This was not there earlier. Earlier we had first aid provisions, but now they have brought in ambulance room. There's no provision for first aid in the court now. Also, transgender employees. Now, welfare officer provisions are more or less the same earlier and now. But what are the qualifications, duties, and conditions of welfare officers are not listed out in the code. Now, you'll also have a creche facility. Now, creche facility is available only for the employees, for the children of the employees, not of the workers. Okay. Now, why? I don't know. What the workers have done, I really don't know. That's how it is. Now, annual leave with wages, earlier it was 240 days. Now, if you have worked for 180 days, you are eligible. From provisions, some more will say. Now, return, yes. Now, if you see here, the new code and the draft rules, they have done away with quarterly filing. Going forward, there will be only annual filing. Now, if you go to the rule, they say you have to file the annual return for the calendar year, that is from January to December of the previous calendar year by 1st of February. Whereas if you go to the form 11, it says you have to file before February 28th of 2019. There is a discrepancy that the government has to correct it. Of course, there are no quarterly returns. Now, they are also coming up with something called an inspection scheme, because the inspector, some facilitator or any authority, he can't do inspection the way he wants to. The government is planning to come up with an inspection scheme so that, the inspectors will work under the purview of the scheme. And it will be web-based inspection. How they are going to implement, we'll wait and watch. Of course, in the other tax laws and all, we do web-based inspection. Web-based assessments and all do happen. But I don't know here in the court how they are going to implement this. They are going to randomly select. Maybe they'll do some sample verifications or something like that. So of course, they're also planning for third-party audit. Now, another very, very important provision, Section 22 or Section 22A of the Mines Act 1952. Now, today in the code it is Section 38. Now, Section 22 was a very dreaded provision maybe about 15-20 years back. We were scared of having high walls. We were scared, what will happen? The PPMS or the DMS may not allow us to work and blah blah blah. But of course, today those things are gone because the owners have awakened. There are a lot of safe provisions being adopted. So now, similar provisions we have in Section 38. Now, in the code. Now, earlier, if there is a dispute between the mine owner and the inspector on the applicability of Section 22, we were representing to the government. The mine owner was, in case of a dispute, was writing to the central government. The central government was referring to the committee, Section 12 committee, which they have done away with now. Now, the committee is gone. The central government itself will dispose of the matter. It will not refer to any committee. If required, they may refer to the advisory board, national board. Now, there is also a provision. The chief inspector, for reasons to be recorded in writing, he can reverse or modify any order passed by him. I think this is little dangerous, because how can a person who has passed an order, he can nullify his own order? He can't make his own order void. Ideally, if an officer, it doesn't matter whether it's a chief inspector, he has passed an order, there should be some more authority above him who can nullify. He himself will not nullify his order. So this is one provision I think they have commented. So moving forward, of course, officials will have to maintain secrecy of the information. Now, there is something, they are saying, you go to section 39, little bit they want to bypass RTI Act, Right to Information Act. They are saying, notwithstanding anything contained in the Right to Information Act, no inspector or the chief inspector will give you any information without taking consent of the complainant. It is good in some ways, it is also bad in some ways. So we'll have to wait to see how they are going to implement this. So employment of women, it's already discussed enough. Contract labor, yes, they have brought it to compulsory. If you are employing 50 or more, then you have to employ from a contractor who is registered, who has got the license. Otherwise, you are not supposed to employ. And this license is valid for 5 years. Then the wages, the contractor, the wages to be paid by the contractor should be disbursed through bank transfers only. You can't give in cash. The contractor license is specific to the establishment. Now, where any principal employer of an establishment is employing contract labor and that contractor who is required to obtain license, it is not obtaining a license, then the principal employer will be in contravention of the provisions before. So mind you, going forward, in case if you are employing a contractor, ensure he has got a license. So prohibition, it's already been discussed. Now, interstate migrant workers, I already told. In fact, they have gone to the extent that we also have to pay journey allowance to travel from the native state to the destination state in case if you are going to employ interstate migrant workers. In fact, government wants to make available PDS benefit, public distribution benefits, rations, in the destination state where he is employed, or an option be given to him whether he can take rations in the native state or in the destination state. That is how they worded. Now, managers. This is one critical thing. I think another 2-3 slides I'm going to complete. This is already it's 130, 135. Now manager. Now, if you go to the provisions, now they are talking underground metalliferous, open cast metalliferous. Now, instead of the average employee, they are bringing in, if the average output is in excess of 1,250 tons, then you will have first class manager. If the average output is less than 1,050 tons, then you will have to have a first class manager or a second class manager. In an open cast mine, they are saying 20,000 cubic meters material handling, or average material handling per month is less than 20,000 cubic meters. But for the first time, they have given a thought, if a mine having both open cast and underground workings, whether they are able to have first class manager holding coal or metal, as the case may be. So what are the issues in this? Underground metal, they are saying average output. They are not clarifying whether it is ore or waste. See, mind you, from an underground operation, there could be some amount of waste coming to the surface. Now, they are saying 1,250 tons, whether it is daily, weekly, monthly, quarterly, yearly, nobody knows. They are silent on it. If you go to open cast metal, they are saying average metal handled per month. That is 20,000 cubic meters. Now, is it where? Is it ore or is it waste or is it both? Nobody knows. Now, average metal handled, whether it will be in the operational area of the mine or whether it can be any other part of the mine, they have to clarify. Open cast and underground. What if I have both, say, lignite and something else? One is underground, one is open cast. Then what will happen? Whether I have somebody put coal or metal. Now, if the work is being carried on by a system of deep hole blasting, whether I should have first class, second class, they're silent. Whether the work is being carried out by heavier moving machineries for digging excavation, I should have first class, or anybody below, they're silent. What about permit managers? 4 men working as a manager for 12 months after taking permission from DGMS. They're silent. In fact, they're buried the status of permit managers. There's no sign of what about appointment of assistant managers, engineers? Probably when they come up with the regulations, maybe they will have. Penalties already been discussed. I'm not getting into this. What penalties used to be a few hundred and thousand rupees, they have now increased to a few lakhs, and there is, what should I say? There is imprisonment also. These are some forms. They have come up with 16 forms. If you go to the rules, you'll find all of these forms. Now, 2 slides, I'm done. Now, what are the provisions that are not considered in the code? Drinking water. Earlier we had in section 90 and then rule 31, 30, 31, 30, 31, 32. Somehow they are silent on drinking water. Probably the government thinks today is the era of all bottled water. So maybe they think the employees will carry their own water bottles or filtered water. So they are silent on drinking water. Earlier it was dealt, elaborated. They also had gone to the extent of saying that a minor should provide 2 liters per person. All that is missing in the code and the rules. Medical appliances first aid, there's no mention of it in the code. They speak about ambulance but not the first aid. Working, of course, they speak about 48 hours, not more than 48 hours, but they're silent on 9 hours a day. It is kept at 8 hours. Then workman inspector, in fact, there's no mention of it. They have done away with workman inspector. Earlier in the Act, Mines Act and the rules, we had specifications as to how one should have, one should build a lavatory, shelters and canteens. They're silent on all this. Now, persons holding supervision or management, who are these people, who come under the category of supervisor category or the management cadre? They were defined. Section 37 read with Rule 46, the old law. But today they are silent. So that's all I had. So, of course, I don't know if the time permits and if the chairman allows, we can have some questions. That's all from my side. Thank you very much once again. Thank you.
Thank you, Mr. Vijay Singh, for your elaborate and highlighting the important issues which are in this code. I think our other speaker, Mr. Venugopal Swami, also noted all these issues. I think we'll flag this to the director and the deputy director so that they can answer some of the questions. So we'll send him through mail and we'll get the answer. Then we can share with all other participants also. Since already we are late by about 45 minutes. So just I will ask, give an opportunity to our Venugopal Swami to throw light on this. So Venugopal Swami to throw light on this. So Venugopal sir.
Yes.
Yeah. So you want to say something?
Can you hear me?
Yeah.
Definitely there are some things to be addressed. Omissions as part, you see, this is regulation is being given. Now many things will be covered in the, rules are being notified for suggestions and any problem is there, we can definitely communicate to the authority, as it is mentioned in notification. And the rest, the working part, the regulation is left out. The regulations, when it comes, it will give broad picture about the functioning of the mines and all. And as far as I want to say that like crutch and all everything, it is covered to the employees. Employee means the workers also will come under the employee. Even officer is also an employee, like management and all. So the crutch is uniform for everything. And of course, there are few things which can be sent in appropriate manner to the competent authority as we have time. 45 days time is been given. Within that, we can suggest. Then the necessary corrections will be made when the actual rule comes. And any doubts, all the points you can send us in email. We'll give reply in email. Okay.
Sir, thank you. Sir, we will share all these issues with you so that you can present your point of view, sir, so that can be shared with all the participants. I think with this, already we are delayed when it's lunch hour. I think thank Mr. A.R. Vijay Singh for his preparation and the presentation. I also thank Muralidhar Bidri sir and Venugopal sir for your time and wonderful presentation today. I think with this, better we can conclude. Anyone has any specific question, or shall we conclude? Anyone has any specific question? I think it is the lunch time. Our participants also will be waiting for the program to conclude. So with that, I think it is the time to propose vote of thanks. So before that, once again, I thank our sponsors, Vedanta Limited and ERM Group for us. I thank our sponsors, Vedanta Limited and ERM Group. So those are supported even today. I also thank all the office bearers and senior members of Bangalore chapter. They are very active in all the events of the chapter. And I special thanks to our national president, Mr. Sanjay Kumar Patnaik, Mr. Madhusudana, Vice President, and our Secretary General, Mr. Narsaya. So I thank almost all the members who have taken time and joined in this webinar. Now I request Secretary Bangalore chapter, Mr. N. Rajendran, to propose a formal vote of thanks to all the. So over to Mr. Rajendran.
Thank you, Chairman. It's my pleasure to propose the vote of thanks on the occasion of this OSH WC Code 2020 webinar. At the outset, I would like to thank our President, Mr. Sanjay Kumar Patnaik, who has taken time out and addressed the participants and highlighted some of the points of the new code. I also thank Narsaya, who has given an essence of the Act, which has subsumed nearly 23 acts and 63 sections into 4 codes. And I also very much thankful to our Vice President, Madhusudana, who has taken time out and been with us during this seminar and webinar, and has given the salient features of the code and its importance for the both employees and as well as employers. So I also thank our speakers, Mr. Muralidhar Badri, Director Mine Safety, and Venugopal Swami, Deputy Director Mine Safety. So for their time and also the preparation they have made and presented nicely all the sections and codes of the new act and explained some of the issues which has been raised. And I also thank Mr. Vijay Singh, who is a specialist in identifying the gaps in all the rules and regulations. And he has very nicely presented the points which has been taken note of by Mr. Gopal Swami, and we will be able to submit the details, all these things to them, and so that they can take care of some of the gaps which has been pointed out by him in the rules and acts also. I also thank our senior members like K.R. Krishnamurthy, Dr. Venugopal, Deepak Vidyarthi, and P.V. Rao, who is taking part for seminar conference, and other council members who are there with us actively participating in organizing the seminar. I also thank all the participants who has spent the time and be with us to make this event a success. And I thank Mr. Sabhajati Nayak and Sudarshan of Minds Magma for organizing the wonderful webinar through this GoToMeet platform. I also thank our sponsors, R. Praveen Chandra of ERM Group and also Vedanta, who has contributed for the event and make us successful. I thank Mr. Dhananjay Reddy, Chairman, who has taken a lot of interest in organizing this event and nicely conducted this program successfully. Thank you once again for all of you for participating in this event. Thank you very much.
Thank you, sir. Thank you very much. So I thank each one of you for your time and support. So again, shortly, once again, we'll meet in some other webinar. So we'll continue our legacy. Yeah. Thank you, sir. Thank you, everyone. Thank you very much.